Labo, JRV Cumlic, Supra. The doctrine of residential judicata does not apply to questions of citizenship. Modes of losing Philippine citizenship. Naturalization in a foreign country, express renunciation of citizenship, subscribing to an oath of allegiance to support the constitution or laws of a foreign country. The annulment of Labo's Australian citizenship as a result of the finding that his marriage to an Australian national was bigamous did not automatically restore his Philippine citizenship. Menzon v. Pedala 197 SCRA 251. Facts. On February 16, 1988, by virtue of the fact that no governor had been proclaimed in the province of Leyte, the Secretary of Local Government Luis Santos designated the Vice Governor, Leopoldo E. Pedala as acting governor of Leyte. On March 25, 1988, Aurelio D. Menzon, a senior member of the Sangguniang Panlalawigan, was also designated by Secretary Luis Santos to act as the Vice Governor for the province of Leyte. Menzon took his oath of office before Senator Alberto Romulo. The provincial administrator, Tenyu Quintero, inquired from the Undersecretary of the DILG as to the legality of the appointment of the petitioner to act as the Vice Governor of Leyte. Undersecretary Rubler stated that since BP 337 has no provision relating to succession in the office of the Vice Governor in case of a temporary vacancy, the appointment of the petitioner as the temporary Vice Governor is not necessary, since the Vice Governor who is temporarily performing the functions of the Governor could concurrently assume the functions of both offices. As a result of the foregoing communications between Tenyu Quintero and Jacinto T. Rubilar, Jr., the Sangguniang Panlalawigan, in a special session held on July 7, 1989, issued Resolution No. 505, where it held invalid the appointment of the petitioner as acting Vice Governor of Leyte. The petitioner, through the acting LDP Regional Council, Attorney Zosimo Alegra, sought clarification from Undersecretary Rubilar, Jr. regarding the June 22, 1989 opinion. Undersecretary Rubilar replied and explained his opinion, on the basis of the foregoing and considering that the law is silent in case of temporary vacancy, in the office of the Vice Governor. It is our view that the peculiar situation in the province of Leyte, where the electoral controversy in the office of the Governor has not yet been settled, calls for the designation of the Sangguniang member to act as Vice Governor temporarily. In view of the clarificatory letter of Undersecretary Rubilar, the Regional Director of the DILG, Region 8, Resurrection Salvatierra, on July 17, 1989, wrote a letter addressed to the acting governor of Leyte, Leopoldo E. Pedala, requesting the latter that Resolution No. 505 of the Sangguniang Panlalawigan be modified accordingly. Despite these several letters of request, the acting governor and the Sangguniang Panlalawigan refused to correct Resolution No. 505 and correspondingly to pay the petitioner the emoluments attached to the office of Vice Governor. Thus, petitioner filed before this court a petition for certiorari and mandamus. The petition sought the nullification of Resolution No. 505 and for the payment of his salary for his services as the acting Vice Governor of Leyte. In the meantime, however, the issue on the governorship of Leyte was settled and Adelino Larrazabal was proclaimed the governor of the province of Leyte. Issue 1. There was a vacancy held yes ratio. The law on public officers is clear on the matter. There is no vacancy whenever the office is occupied by a legally qualified incumbent. A sensu contrario, there is a vacancy when there is no person lawfully authorized to assume and exercise at present the duties of the office. Applying the definition of vacancy to this case, it can be readily seen that the office of the Vice Governor was left vacant when the duly elected Vice Governor Leopoldo Pedala was appointed acting governor. In the eyes of the law, the office to which he was elected was left barren of a legally qualified person to exercise the duties of the office of the Vice Governor. There is no satisfactory showing that Pedala, notwithstanding his succession to the office of the Governor, continued to simultaneously exercise the duties of the vice-governor. The nature of the duties of a provincial governor call for a full-time occupant to discharge them. More so when the vacancy is for an extended period. Precisely, it was Petala's automatic assumption to the acting governorship that resulted in the vacancy in the office of the vice-governor. The fact that the Secretary of Local Government was prompted to appoint the petitioner shows the need to fill up the position during the period it was vacant. The department secretary had the discretion to ascertain whether or not the provincial governor should devote all his time to that particular office. Moreover, it is doubtful if the provincial board, unilaterally acting, may revoke an appointment made by a higher authority. Issue 1. The Secretary of Local Government had the authority to designate the petitioner. Held yes ratio. The Local Government Code is silent on the mode of succession in the event of a temporary vacancy in the office of the vice-governor. However, the silence of the law must not be understood to convey that a remedy in law is wanting. The circumstances of the case reveal that there is indeed a necessity for the appointment of an acting vice-governor. For about 2 years after the gubernatorial elections, there had been no de jure permanent governor for the province of Leyte. Governor Adelina Larrazabal, at that time, had not yet been proclaimed due to a pending election case before the Commission on Elections. The 2-year interregnum which would result from the respondents' view of the law is disfavored as it would cause disruptions and delays in the delivery of basic services to the people and in the proper management of the affairs of the local government of Leyte. Definitely, it is incomprehensible that to leave the situation without affording any remedy was ever intended by the Local Government Code. Under the circumstances of this case and considering the silence of the Local Government Code, the court rules that, in order to obviate the dilemma resulting from an interregnum created by the vacancy, the President, acting through her alter ego, the Secretary of Local Government, may remedy the situation. We declare valid the temporary appointment extended to the petitioner to act as the vice-governor. The exigencies of public service demanded nothing less than the immediate appointment of an acting vice-governor. It may be noted that under Commonwealth Act No. 588 and the Revised Administrative Code of 1987, the President is empowered to make temporary appointments in certain public offices, in case of any vacancy that may occur. Albeit both laws deal only with the filling of vacancies in appointive positions. However, in the absence of any contrary provision in the Local Government Code and in the best interest of public service, we see no cogent reason why the procedure thus outlined by the two laws may not be similarly applied in the present case. The respondents contend that the provincial board is the correct appointing power. This argument has no merit, as between the President who has supervision over local governments as provided by law and the members of the board who are junior to the vice-governor, we have no problem ruling in favor of the President, until the law provides otherwise. A vacancy creates an anomalous situation and finds no approbation under the law, for it deprives the constituents of their right of representation and governance in their own local government. In a republican form of government, the majority rules through their chosen few, and if one of them is incapacitated or absent, etc., the management of governmental affairs to that extent may be hampered. Necessarily, there will be a consequent delay in the delivery of basic services to the people of Leyte if the governor or the vice-governor is missing. The appointment of the petitioner, moreover, is in full accord with the intent behind the Local Government Code. There is no question that Section 49 in connection with Section 52 of the Local Government Code shows clearly the intent to provide for continuity in the performance of the duties of the vice-governor. By virtue of the surrounding circumstance of this case, the mode of succession provided for permanent vacancies may likewise be observed in case of a temporary vacancy in the same office. In this case, there was a need to fill the vacancy. The petitioner is himself the member of the Sangguniang Panlalawigan who obtained the highest number of votes. The department secretary acted correctly in extending the temporary appointment. In view of the foregoing, the petitioner's right to be paid the salary attached to the office of the vice-governor is indubitable. The compensation, however, to be remunerated to the petitioner, following the example in Commonwealth Act No. 588 and the Revised Administrative Code, and pursuant to the proscription against double compensation, must only be such additional compensation as, with his existing salary, shall not exceed the salary authorized by law for the office of the vice-governor. And finally, even granting that the President, acting through the Secretary of Local Government, possesses no power to appoint the petitioner, at the very least, the petitioner is a de facto officer entitled to compensation. There is no denying that the petitioner assumed the office of the vice-governor under color of a known appointment. As revealed by the records, the petitioner was appointed by no less than the alter ego of the President, the Secretary of Local Government. After which he took his oath of office before Senator Alberto Romulo in the office of Department of Local Government Regional Director Residential Salvatierra. Conceitedly, the appointment has the color of validity. The respondents themselves acknowledged the validity of the petitioner's appointment and dealt with him as such. It was only when the controversial Resolution No. 505 was passed by the same persons who recognized him as the acting vice-governor that the validity of the appointment of the petitioner was made an issue and the recognition withdrawn. The petitioner, for a long period of time, exercised the duties attached to the office of the vice-governor. He was acclaimed as such by the people of Leyte. Upon the principle of public policy on which the de facto doctrine is based and basic considerations of justice, it would be highly iniquitous to now deny him the salary due him for the services he actually rendered as the acting vice-governor of the province of Leyte.